evening, everybody. My name is Fiona Cownie, and I'm chairing the first part of the evening. I'm a professor at Keele University, and it's my great pleasure to welcome you this evening to this celebration of the republication of women in the law. Firstly, I'd like to introduce everybody who's going to kind of play a part in the evening. So obviously on either side of me I have the authors of the book, so Lady Justice Hale and Dr. Susan Atkins. So our conversation will be followed by a panel discussion which will be chaired by Professor Diamond Ashiagbor of Kent University, and the panel will include Professor Mulcahy of the LSE, Professor Alison Diduck from UCL, and Professor Erika Rackley from Kent. So they will do their part of the evening, and then after that there will be the opportunity for you to ask questions and make comments. So we will just seamlessly, we hope, go from our conversation to the panel, and then there'll be questions at the end. So I just wanted to give you a little bit of kind of background to the republication of this book. So it's part of the Humanities Digital Library, which is an initiative of the School of Advanced Studies here at London University, with whom the institutes here are partnering in order to produce the digital library. So it produces free to download monographs. So Women in the Law is the third of our publications in this series. We are in the process of commissioning more. We're very excited about the series. I'm particularly excited that Women in the Law can showcase so effectively this new series and this new initiative for the Institute. So without further ado, I'm going to start my conversation with the authors. So I'm going to sit down to do that, and I hope you can still hear me. But if you can't, just wave from the back and we'll shout louder. So, Brenda, I'd like to start with you first, please. Can you tell us a bit about the story of Women in the Law? You know, how did it happen, and how did the original idea come about?
Well, it came about because some of you, I'm sure, will know a very fine book called Race and the Law by Anthony Lester and Geoffrey Bindman. And the publishers, who were Blackwells at the time, William Twining, and I'm trying to remember who else it was, wanted to do a sort of companion volume on women and the law. And at that stage, well, they approached me and a colleague in Manchester University to do it, and we said yes, we would do it. But for a variety of reasons, it didn't get done for some considerable time, which was not a bad thing, because quite a lot happened after that initial approach until eventually the collaborator in Manchester couldn't do it, and so we had to look around for another collaborator, and there we found somebody who knew much more about the subject than I did, and who joined the team, and we got it done. So that's how it came about. It was the idea of having a companion to Race and the Law.
Oh, right. Okay. So, Susan, perhaps you could tell me, how did you go about writing it together? Because that's always a difficult thing to do, to collaborate with somebody.
Well, the first thing is, Brenda, one shouldn't really contradict the President of the Supreme Court, but she was wrong. I didn't know more than her. I think it was a true partnership, wasn't it?
It was, yes.
Brenda, I've done published some articles in the Journal of Social Welfare Law on Social Security with a feminist analysis. So I'd come to Brenda's attention, and she invited me up to Manchester, which was my hometown. So it was lovely to go back. And I seem to remember, Brenda, we had a jolly good conversation. At the end of it, we decided we could work together, and we would follow the public-private divide.
Yeah.
And we both had subjects that we were specialists in, but we did have some common ground between us. So I taught family law, though I wasn't a family law expert. And between us, we knew something about social security law. So it was good fun. And basically, We split it up, and I think at that first meeting we more or less worked out what the chapters should be. You've obviously done some previous thinking about that.
Yeah.
And we wrote a chapter, swapped, got a lot of comments together, and I think what was really fun for me was seeing how we were able to suddenly break down the silos between law and begin disciplines of law and subjects of law and see the interlinking. It worked really well.
I think that's what was beginning to happen at that time. You know, we're talking late 70s now, and people were thinking outside the traditional categories of legal subjects. It was happening in other areas as well. And what we decided to do was, instead of saying, well, women and tort, women and property law, women and crime, or whatever, we would look at it from the woman's point of view. You know, how do I get educated? How do I run my sex life? How do I go about being a mother? How do I get on with partners? How do I run my family life? How do I get out to work and, you know, get properly paid and equal treatment at work? And how do I get treated in the tax and social security system? And what about participation in public life and citizenship? Just looking at it from those sorts of points of view, that was part of our collaboration, because we could both bring something to each of those chapters.
So it was very much from the point of view of women living their lives, really,
Definitely.
how the law affected them.
Yeah.
So what do you remember about the original reception of the book? I mean, I believe it was shortlisted for the Fawcett Prize, so somebody must have loved it.
That was quite funny, wasn't it? The Fawcett Prize has fiction one year and non-fiction the next. And we were one of 6 books shortlisted for the non-fiction prize, obviously, because we weren't making it up. We'll never forget the awards dinner. It was held in the restaurant at the London Zoo, which was quite funny, really, wasn't it? You know, the women all enjoying themselves in the company of the animals, so to speak. But we didn't win.
But we had a nice evening.
We had a lovely evening, yes. Marina Warner won.
Monuments and Names.
Yes. And our book was described as solid. Good, solid, interesting piece of work, they said. Yes. So we thought, okay, dull.
I think it fell into a gap, really, initially, because the critical legal studies movement was taking off. And it was a very vibrant time. I mean, a lot of people here were writing at the same time. And so we were seen to be probably quite solid in terms of our rather traditional way of looking at law. We weren't really sufficiently ahead of the game there. But the traditional law academia hadn't quite caught up. So I remember the reception being quite mute, don't you? It didn't really cause very many ripples. It was only sort of later on, I think, that people began to understand that actually we had contributed quite a bit.
Yes, I was quite staggered when I first met Helena Kennedy, when I came down to London, and probably a few years later, and she said, "Oh, you wrote that magnificent book," and she said how greatly it had affected her and thinking about things, and others she knew. And of course, we, being in academic life, we didn't really know that it had affected practitioners as well.
And for me, I met Tove Stangdahl here in the Institute. It must have been about '86, and she had written something quite similar in Norwegian in Oslo. And we had a Swedish au pair at the time, so Tove said, "Well, I could send you a copy of my book, but you won't be able to read it." And I said, "But I know somebody who can." And I remember she invited me to teach in Oslo, and meeting students from Africa and around the world on their international development program, which said, "You know, I've read your book, and this is the late '80s, and what an impact it made." And that was terrific, you know, just thinking that we had an outreach.
Yes. It was really about the reception, your reflections on the book now that it's been in existence for all these years, and you're beginning to realise what kind of ripples it has had, how you feel about that. Really.
Well, some of the things that we complained about, we managed to do something about. So I suppose we should feel quite pleased about that. From time to time, I've come across a problem and I've looked back to see what we said about it. Not necessarily for an answer, but for a way of thinking about it. So I've never really forgotten the book. It's been quite influential to me. And that was, Sue played a large part in that because she helped very much with my thinking about all sorts of issues. But I did move on to other things fairly soon afterwards. So.
And I went into the civil service, and it's really been interesting going back and reading the book. I wrote the chapter on citizenship and women in public life. And rather like you, Brenda, I thought, oh gosh, well obviously, subliminally, this did make a difference because, you know, as a senior civil servant, I led the Women and Equality Unit in the Cabinet Office, and we helped Margaret Jay and ministers put through the positive action movement, the women-only shortlist, the Sex Discrimination Election Candidates Act in 2002. No, I don't think I would have been so concerned about women on public appointments if I hadn't written that chapter, and understanding that a lot of law was being made or influenced behind closed doors, and it was important to get women into the civil service, into the high elections, into public life, and on expert committees. So I think it did make a difference, although I wasn't, once I left academia, I wasn't as sort of aware that it was influencing how I worked.
So revisiting the book now and writing the new foreword, how was that?
Well, I think it was great fun. Writing the book was great fun, and writing, going back to it again was, we wrote it together, didn't we? And then Brenda said, typically, you've done most of the work, so you put it under your own.
So you enjoyed the foreword, really, and
Yes.
writing that as well?
Well, for me, I left law in '89. I'm coming back and working on the women legal landmarks again, and then coming back to this. It was a really opportunity for me to take stock of actually how the law has moved on. So it was very, very positive in that regard. And how much had been lost. The point we make about universal credit being paid into the household and the impact of that. So you think people had forgotten about the fight we had for women's independent taxation. So it's, you know, it's important that the book is there. History is important because it gives a context, so people working today can go back and remember those things, and hopefully not make the same mistakes.
And I was wondering how much you thought that events had caught up with the hopes and expectations that you had. You were mentioning about having managed to change some things. I was wondering what the changes were that kind of immediately sprang to mind, which were kind of women in the law related.
Well, the two that instantly spring to mind, and you can look at it in either way, but one of the things that we talked about in the parenthood chapter was encouraging more sharing of parental roles. And so one of the things that the Children Act did was to try and encourage more sharing of parental roles. Now, that can, of course, have deleterious effects if, in fact, nothing much is shared other than power. But it's, in principle, it's the right thing, and you stop putting different roles in different genders and making various assumptions. And the other one is the definition of violence, which, well, the sharing thing came out of the Children Act, which I had something to do with when I was at the Law Commission, and the notion that violence is a wider subject than just hitting or threatening to hit is something that I managed to convince 3.5 of my colleagues of in a case called Yemshaw. So that definitely came very much out of the insights that we developed in the book.
And you see it, well, I see it now with the work I'm doing on the ground in the sharing of parenting, parental leave. I've just done some work looking at women in the armed forces across the European area for the OSCE. And the amount of sharing in military between men and women, you know, who are some of the most conservative in society. It's not just here. So you've got the private and the public again reinforcing them. Although of course there's more men who probably would like to take that, sure, feel able to. And one of the challenges is that men are now facing the same sort of problems, combining their parental responsibilities and their work responsibilities as women have for the last hundreds of years.
Well, thank you very much for participating in this conversation. I'm sure everybody's absolutely fascinated. The audience has been like completely still, which suggests that they are absolutely fascinated, and it's been lovely to talk to you. Is there anything else that you would like to say?
Well, what I'd like to say is if anybody's got any questions, because I might have to disappear quite soon, although I don't want to, if there were any questions that anybody wanted to ask, would it be all right to...
We should just take a few now. Well, I think we should thank our authors very much for fielding all those questions and for sharing with us the story of women in the law. Thank you both very, very much indeed.
I'm Diamond Ashiagbor, and I'm Professor of Law at University of Kent and also a Senior Research Associate here at the Institute for Advanced Legal Studies. I want to say thank you so much to Baroness Hale and Dr. Atkins and Professor Fiona Cownie. Obviously, the two authors of the book, thank you so much for writing the book and then agreeing to republish it with the IALS Open Access series. So for this panel, what we've asked our three panellists to do is prepare short reflections on what women in the law has meant to their teaching, research, career and or activism. And then after these reflections we'll have a discussion amongst the panel before opening up to wider participation from you. It's great to see so many people here. I just want to say looking at the book again, this was something that I studied. I mean, I was studying family law, legal theory, 3 or 4 years after the book was published. I was studying labour law, and so reading the book again, some of just that sense of I couldn't believe to be reminded of some of the frustrations I felt as a law student reading these equal pay cases or reading these cases about sexual violence. And we're going to hear lots of different observations about the substantive issues discussed in the book. I just want to say something about method and engagement with legal writing. As the authors explain in the original 1984 preface and in the introduction, this is not a legal textbook. We set out to examine the law's treatment of women, not from the point of view of the law itself, but from that of women whose lives it governs. But they also explain this is not a work of history or sociology. And in their foreword to the 2018 republication, we also made a series of insightful observations about how feminist scholarship, feminist legal scholarship, was perceived at the time of initial publication. That feminist legal scholars experienced additional barriers to publishing in having their work valued. Their analysis was viewed as sociology rather than as law. And what I think is one of the many, many really important contributions this book made was for us to think about what legal scholarship is and looks like, in that this kind of insight is both inside and outside of law. Law isn't just about interpreting doctrine, regulations, rules. It's also about the broader social economic context. And what this book reminds me of again is how feminist scholars have always done both, to interweave the doctrinal, what the statute says, what the case law says about rape in marriage, with the sociological or the psychological or the historical. So that was just reading it again as a legal academic rather than a law student. That was just one observation on slate. So I now want to hand over to Alison, Diduck, Linda, Mulcahy, and Erika, Rackley, just to say something about some of where they're coming from. Alison, prior to academia, was practicing barrister and solicitor in Canada. Her research interests in child and family law, legal theory, feminist perspectives on law and legal history. Linda's currently professor in the law department of LSE, specialising in socio-legal approaches to study law and legal phenomena. She's about to move to the position of Professor of Socio-Legal Studies at the University of Oxford. And her qualifications are in law, sociology, history, arts and architecture, and she works at a strong interdisciplinary flavour and empirical focus. Erika is Professor of Law at the University of Kent, as I am, and her research focuses on judicial diversity, medical judging, feminist legal history, and image-based sexual abuse. And one of her current projects is on the women's legal landmarks, which Dr. Atkins mentioned earlier. So I'll hand over first to Alison.
Thank you, Diamond. Thank you, fellow panel members, and thank you, authors, and Fiona. And thank you, everyone, for being here. I'd like to share with you my own way into feminist law and the place of this book and its ideas in that journey that I've taken since 1979. My feminist roots began with activism and then legal practice. So I became aware of this book late, or at least later than some of the people in this room. When it was published in 1984, I was working as a lawyer and as a rape crisis counselor in Winnipeg, Canada. As I've shared before, I think Erika might remember, in the rape crisis movement, together with other women and men, we took to the streets to take back the night. We went to government to agitate for funding, and when that didn't work, we held car washes to raise money for the sanitary. We went to libraries, we went to schools, we went to universities to speak about violence against women. We went to police stations and hospitals, to the legislature and to the courts to advocate for law reform and to advocate for our clients. Most importantly, we worked with rape survivors. We were simply trying to do something about the appalling circumstances of the women that we worked with, which meant that we had to think about government, law, cultural, religious practices, the distribution of economic and political resources, and the expression of intimate and non-intimate relationships. It also meant that we had to think about relationships to forms of power and about the different ways people were differently placed to exercise that power. I then took all of these experiences with me to law school, where they informed the way I thought about law. After that, I took them to my legal practice, where it meant that when I prepared legal argument for the courts, I wanted to understand how to fashion that argument in a way that took seriously the voices of the many women with wired jaws or broken arms who sat at my desk and told me they still loved him, the man who had hurt them. With all these experiences, I tried to understand the ways in which power, class, gender, race, and economics are always intertwined in our intimate and in our public lives. And then I came to the UK to do graduate studies in 1987, and I found this book. It was a revelation. Not only did it express so clearly and so frankly the legal situation of women in the 1980s, it helped me to understand my rape crisis experience and my practice experience. If only there had been something like it on my LLB curriculum in Canada in the early 80s. There were popular books out there that were written about rape or domestic violence, but this book did it as legal scholarship. It referenced legal history, social policy, legislation, and jurisprudence. It raised issues and it named issues that previously had no name or were unable to be comprehended in law and policy at the time. When I returned to Canada after my studies in 1989 to return to practice and teach law, I took this book with me. In my 3 years teaching at the University of Manitoba, the ideas from this book were reflected in the way that I taught my family law class and my legal history class. More than that, though, the very existence of this book, just imagine legal scholarship that takes women's lives seriously, was as important as its content. Its existence legitimized women's issues and women's particular relationship to a non-neutral law. And its content reinforced to me the value of a historical perspective as a way to make sense of current law. It also made me feel braver in being able to identify and to challenge where law continued to rely on gendered assumptions that came from that history. The ideas in the book also inform my legal practice. Acting for the Women's Legal Education and Action Fund, for example, in a case called Moog against Moog, a case about property and spousal support after divorce, we were granted intervenor status in the Supreme Court of Canada in 1992. We included in our argument the disturbing feminization of poverty. We argued that that phenomenon was related to the roles undertaken by men and women during marriage, and that to pursue economic self-sufficiency after divorce, which was then the objective, the judicially created objective in the law then, that violated principles of fairness and equality. The majority of the Supreme Court of Canada said, to elevate economic self-sufficiency to the preeminent objective would be inconsistent, not only with the proper principles of statutory interpretation, but also with the social context in which support orders are made. There is no doubt, the court said, that divorce, or the majority of the court, that divorce and its economic effects are playing a role in the feminization of poverty in Canada. In most marriages, the wife still remains economically disadvantaged. It would thus be perverse in the extreme to assume that Parliament's intention in enacting the Divorce Act was to penalize women in this country. Okay, keep those words in mind. Think about them. Now let me quote from Atkins and Hoggett, 1984, page 122. The Law Commission discussion document on the Matrimonial Causes Act at the time contains a powerful section on the effects of marriage and family responsibilities upon the position of women in the marketplace. However, it did not discuss whether the attempt to redress those disadvantages could provide a satisfactory model for reform. They then went on to make the case for this model. The main reason a wife cannot compete equally in those domestic responsibilities, which both she and her husband, the main reason she cannot compete equally in the marketplace is because of the domestic responsibilities which she and her husband expect her to perform. If all husbands were prepared to assume an equal share of household tasks and childcare, there might be no disadvantage suffered and no corresponding obligation to provide compensation. At present, however, while men can choose whether or not to marry a wife who wishes to pursue a career outside the home, and I love this phrase, there is usually only one form of husbandly lifestyle on offer to women. In Moog, the Supreme Court of Canada agreed with these arguments, compensated Mrs. Moog for precisely the disadvantage that Atkins and Hoggett identified. It valued those previously invisible, unvalued domestic tasks that women were simply assumed to perform. The author's cogent arguments about the legal and therefore the public recognition of private domestic work have since been accepted, not only in the Supreme Court of Canada, but as the family lawyers here will know, in England and Wales as well, actually in the UK. And I have repeatedly drawn upon them in my work. The book articulated these issues in a way that made sense for the likes of me. It raised questions about the organization of work and the current system for distributing resources outside the home, including political and economic power, and how these are always inextricably linked with the distribution of roles and resources within the home. In this way, it told me that family law is a public law. And employment law, and social security law, and property law, and immigration law are family law. In my later family law practice, it provided a way for me to add to my previous experience and make additional intellectual and legal sense of the claims that all of my clients made when they came to see me as wealthy husbands, abused wives, mothers, fathers, employees. My academic work, it encouraged me to think about people's actual experiences with each other, rather than about merely abstract concepts or principles. It offered a way for me to insist in my academic work that we must look at what people actually do in their private and their public lives, and that there's both symbolic, importantly, and material value in all that different work. In a sense, it helped me to locate experience in law and to locate law in experience. I reread the book last month, and what was striking for me that while almost all of the law has changed, and indeed much has improved, there are still aspects of women's lives in the law that remain stubbornly the same. The feminization of property is still a real phenomenon. There is still what the authors called then a considerable gap between what husbands say and what they in fact do in their families. Political representation is still a feminist issue. And in family law, we may be seeing a pushback against advances in fairness for women that were made by the House of Lords and the Supreme Court in England and Wales, and in the family courts a few years ago. In a return to abstract ideas like formal equality and autonomy, the courts may be losing sight of the lessons in this book about the importance of people's real experience and law's questionable neutrality and objectivity. Perhaps some of the family court judges should reread this book too.
It was a genuine delight to be asked to contribute to this celebration of women in the law tonight, and especially to the two women who gave birth to the book. My own academic career has been enhanced by both the authors. Sue taught me when I was 18. She taught me criminal law. She was a really fabulous lecturer. And I worked on Brenda's team at the Law Commission as a very lowly, unimportant research assistant. And I'd like to start by offering my personal thanks to both Sue and Brenda for the work they did in 1984. I come from a family that didn't enjoy absolute possession in fee simple, had never been involved in a charter party, and didn't have any secret trusts. So I struggled in my first year at university. And I actually told my personal tutor in January of my first year that I was thinking of leaving. The crisis of the week was that I just couldn't find a ratio decidendi, and I thought that was a problem instead of being quite a natural thing. And he persuaded me to stay on, and I'm eternally grateful to him for that. He persuaded me to stay on with promises of the optional courses that came after the compulsories, and he was right. So I got the law bug later on in my degree by studying poverty law, sociology of law, juvenile justice, and Sue's specialist course on law and discrimination, in which I guess now that we were sort of the guinea pigs for part of the book. And what that course and the approach adopted in Women in the Law did was to validate my choice of law as an object of study. I was blessed to grow up in a very loving family, dominated by extremely strong women, who negotiated job shares in the 1970s when it wasn't at all common to do so. And they came from families where the women always worked. The concept of the working woman that was a bit of an issue in the press in the 1980s always really confused me. And scholarship in the genre of women in the law, of which there wasn't enough at the time, made the concerns of interest of my female relatives, who didn't have their name on property deeds, who balanced childcare with low-paid work, and whose pin money paid for many of the essentials in our life, legitimate and important. And it also meant that I didn't have to leave them all their worries behind when I went off to get myself an education. I'm grateful to you for rendering the lives of those women important. I thought I was going to be the oldest on the panel,
That's
so I
okay.
was going to say I'm going to talk about what it felt like in 1984, but you've just completely undermined that. I'm on your face cream. I assumed I was older than Alison. And I'm not a specialist in any of the subject matter that is actually covered in the book, but what I did want to talk about was what it felt like in 1984 and what the curriculum looked like in law schools in 1984. I think it was really radically different. And 1984 was the year that I finished my LLB and had to decide what I wanted to do in life. So we all know by now that this book was one of the first of its kind, but I think it's really useful to reflect on what being first in a kind meant at the time, and what a lonely journey being a pioneer can be. Being one of the first means to work without clear theoretical frameworks that have been developed by other people that you admire, without well-established networks of scholars, without national and international conferences that are held on a regular basis in your area, and without journals that are receptive to your work or approach. I have no doubt that it was really tough. By way of reminder, when this book was published, there was no Socio-Legal Studies Association. There was no Journal of Social and Legal Studies, there was no Feminist Legal Studies, there was no Child and Family Law Quarterly, there was no International Journal of Law in Context. Judith Butler had not published Gender Trouble. Naomi Wolf had not published The Beauty Myth. Carol Pateman had not published The Sexual Contract. Kimberly Crenshaw had not used the term intersectionality in relation to feminism. And feminist jurisprudence was a term which had been coined just 4 years before the publication of this book. Female voices within the law were also marginalised. In 1984, we never had a female Lord Justice of Appeal or a female member of the Judicial Committee of the House of Lords. No female Attorney General, no female Solicitor General, not even a female chair of the Bar Council. And Fiona can fill us in on how many female law professors there were in 1984.
I was just thinking probably about 5.
5, okay. Which most law faculties would probably have 5 female law professors now. So books of this kind are now much more common, but I think it's important for us to start by recognising that in 1984, this was tough territory and largely uncharted. The book was also on the cusp of numerous developments at the time. Sue talks in her introduction to the new edition about the time the book was being written as one of transition. We now talk about fourth wave feminism, but this book was born in the era of second wave feminism on the cusp of third wave feminism. It also sat on the cusp of significant changes to the law school curriculum, in which we began to see a gradual movement away from purely doctrinal approaches to law which was embracing of socio-legal and critical approaches. The emphasis on law made this book susceptible to the criticism which Sue's already alluded to from the critics, that it focused too heavily on rights at the expense of structural inequalities and culture. I think that criticism is unfair. The book acknowledges the contributions to the field that other disciplines are able to make in understanding why law and lawyers are the way they are. It does what it says on the tin. It explores the way that law looks at women. The relationship that feminists have to law will always be a difficult one. We all rejoice the test case or the legislation that overturns discriminatory law, while remaining sceptical of the power of law to change structural inequality. But that doesn't mean that we shouldn't be interested in the internal logic of law or pay attention to the way that statutes and cases facilitate inequality and equality in the way that this book does. So, speaking as a socio-legal scholar, I think it's incredibly important for us all to be really good doctrinal scholars as well. So, I don't take the criticism that the critics levelled at this book seriously. It was also a period of hope when this book was written, when many of us, rather naively, possibly, felt that formal recognition of inequality would put an end to many of the disadvantages experienced by women. The Sex Discrimination Act was less than a decade old, and along with the Equal Pay Act was still being tested. The limits of formal rights and interpretation of them by male judges was only just beginning to evolve, and with it another set of problems. In the world of work, membership of the EEC meant that judges were now being exposed to new forms of legal method. And the UK was constantly being criticised for its narrow interpretation of the concept of equality and work of equal value. So it was an exciting time in that sense that the UK government was constantly being challenged. But what we also saw in the higher education sector in the early 1980s were the fruits of the post-war expansion of higher education and the emergence alongside other developments of the plate glass universities, as they became called. This meant that we began to see new types of students, new types of lecturer and new types of courses emerge. I hardly need to explain to this audience the impact of law schools like Kent and Warwick and the enormous effect that they had on the way that we thought about and taught law. We're also witnessing a departure from law schools being seen as centres of vocational training for the professions and the emergence of a clearer sense of law as an academic discipline. This was also reflected in the new focus on academic careers that weren't combined with regular practice, as they still were when I took up my first job as an academic in Bristol. People commonly practised at the same time as teaching. Viewed in that context, I think the opening 6 words of the 1984 edition, "This is not a legal textbook," are really important. In the era of the ref, that sort of statement would be seen as a badge of honour. In an era in which people built academic reputations on the back of the production of a best-selling textbook, which went to several editions, it was a very bold and somewhat provocative statement, I think. This book was also part of a new type of legal scholarship which changed the focus of courses. As people have already alluded to, it didn't emphasise a particular type of legal transaction such as contract or property or trust. It focused on a particular type of legal subject, the woman, and the myriad of ways in which her gender was relevant to the way in which law operated. This was unusual in an era in which it was rare to have courses that cut across traditional subject clusters, a task usually left to jurisprudence or legal method courses. And another prominent example of how this was happening at the time is the emergence of courses on poverty law, which began to spring up, prompted by the birth of the law centres movement. These reclassifications of the lens through which we viewed law were important ways of making certain legal actors less obscure or marginalised in legal practice and debate. It was the sort of breakthrough that allowed Stendhal to suggest more recently that we should have more courses on birth law, homemaker's law and money law. I love those ideas and the fact that this book was one of the publications that helped to pave the way for those discussions. It also encouraged us to think about how we constructed legal topics or study in the first place, to step out from behind the protection of the qualifying law degree to think about how we could frame the syllabus if we wanted to. The book is also an interesting mix of bottom-up and top-down approaches to the study of law. It claims to understand how the law has perceived women and responded to their concerns, but by choosing to focus on the topics that it does, work, sexuality, motherhood, marriage, violence, it also adopts a way of seeing which focuses on how women might encounter and interact with the law. And in doing so, I think we can recognise it as adopting a sort of bottom-up approach to the law which has now become really commonplace. So what about the contemporary context? I think like others, when I picked up this book to read it again last week, I was surprised by its contemporary significance, the significance of the chapter headings to the way that we look at women in the law today. The new introduction reminds us that a lot has been achieved since 1984. But as I read my new copy, I was also reminded of the many things that haven't improved or have not improved as quickly as we wanted them to. The treatment of women during armed conflict and the low prosecution rate of gender crimes, the ongoing gender pay gap, scandals over the incidence of everyday sexism and harassment, the lack of diversity in senior management roles and in the legal profession. When I first read this book in 1984, it made me angry. I think it was supposed to. When I read the book last week, it still made me angry. And I think that should serve as a reminder to all of us that in addition to this being a celebration, we also need to recognise that struggles identified in this book are ongoing. And also that those of us in the audience who are legal educators need to continue to be vigilant in identifying bias in the way that law is taught through what we teach, how we teach it, how we construct our syllabus, and how we put together our reading lists. And to constantly find more books like this one to put on the list. Thank you.
Hi, so I too would like to thank everyone for inviting me to be here. It's a real honour and absolute delight to share the panel with some of my favourite women, which is just amazing. It's also a little nerve-wracking. The brief seemed rather self-involved for a celebration of someone else's book, and also coming last means that I fear I'm going to say much the same, but in a slightly different way, but I hope not too much. In any event, I was very conscious that I came late to the Women-in-Law party. Partly this was out of my control. By the time I started my law degree, Women-in-Law was already a decade old. And although I was fortunate enough to be taught by at least two super feminist academics, Celia Wells and Aileen Fagan, I don't remember encountering the book as an undergraduate. This is likely down to me. By the end of my first term, which I remember as consisting entirely of public law and EU law, but that may well not have been the case, I was pretty disengaged and pretty sure that a career in law, or at least the one that was appearing in the glossy brochures that were appearing in my pigeonhole, weren't for me. A single week in one of the courses that this book helped encourage on feminist jurisprudence in my second year legal philosophy course saved me. This, for me, was an oasis of common sense and practical reality after a term of reading the canon of white men. For the first time, law began to make sense, and it was something that I could get behind, although I still wasn't really sure how. It would take a push by the wonderful Eileen Fagan in the direction of Joanne Conahan at Kent, for me really to begin to find my feet. So all this navel-gazing is to allow me to make 2 points. The first is, like many others, I'm in the position I'm now because of the mentorship and support of other women. This is not something I've simply encountered as an academic. By the time I was an undergraduate in the mid-1990s, the Legal Academy was such that there were more academics about, although when I looked up this afternoon, not so many in Cardiff where I was. There was about 1%, which I'm slightly ashamed to confess I didn't notice at the time. And the sector average was much higher. It was around 39%. More importantly, there were more feminist academics, who often also happen to be women, who thought like me, and not only that, were true role models, and in the fullest sense, who practiced their feminism not just in terms of how they taught, but in the support they gave to students within the academy. As Sue Atkins notes in her wonderful new preface to the new edition, by this time, and certainly by the RE in 1996, feminist legal scholarship was beginning to gain ground. It was something that was appearing slightly on law school syllabuses, and Women in Law led the way, both as a piece of feminist legal scholarship, but also in terms of the teaching. It was at the vanguard of both the increasing recognition of feminist legal scholarship and the studying and teaching of women in law. So, as I thought about it, women in law impacted on my research and my career before I even knew it existed. It contributed to a culture in which I was able to find a place, a culture in which it is possible to make a career out of thinking and talking about women in law, which in broad terms is what I've done. So this is a genuine thank you to the authors of this book and the women who enabled that to happen. My second point is this: for me, despite the author's intention, for me, Women in Law has always been a history book. It's always been a work of feminist legal history. By the time I encountered it properly as a PhD student in the early 2000s, which again was part of my collation of the back catalogue of one of its co-authors, it was well on the way to being 2 decades old. By the time it appeared as a landmark in the Women's Legal Landmarks Project, as one of 93 landmarks, it was midway through its 4th decade. So Women in Law is then both, for me, a book about women's legal history and part of it. It's subject and object of feminist legal history. For me personally, it's been a backbone, a scaffolding, compost even, supporting and feeding not only what I write and research about, but how I do it. And so what does it tell us about feminist and women's legal history? Well, a lot, obviously. It tells us both explicitly and over the course of its pages that despite radical changes in law affecting the relationships between men and women, the process is far from complete. We're not there yet. This was true in 1984, and of course, it's true now, 34 years later, in 2018. Women in Law tells us that law reform, whether legislative or through the courts, is only part of a story. It's rarely the beginning, and it's just as, if not more so, rarely the end. Women in Law warns us never to be complacent as women, as academics, as lawyers, as teachers, as feminists. It tells us about the value and importance of feminist legal history as a political project, of knowing our history, of knowing where we've been and what's gone before. It tells us, to use Rose McDean's word quoted at the end of the introduction, that action without knowledge is no better than knowledge without action. That it is, this time in Atkins and Hale's words, that it's only when women are aware of the extent of discrimination against them, of how it operates, and of how to use the law and to influence law reform to their own ends, that further progress will be made. And so, as we enter a year of celebration of women's formal entry into the legal profession, a year that threatens to be dominated by anecdote and myth, knowing not only where we are, but where we've been, of action with knowledge, has never been so important. The tide of harassment, abuse and violence against women and girls will, we have to believe, one day stop. And when it does, the extent to which feminist activists, academics and parliamentarians have stood on the shoulders and been carried in the arms of each other and those who have gone before will be apparent. In the meantime, how might the current undergraduate know her history? Well, she could do a lot worse than reading this book.
Thank you very much. I want to give you a chance, if you want to ask questions to each other, but before I ask one question which might not be very fair one. Do you think there could be an equivalent book today? If so, what would it look like?
Well, I think there could, and I think there ought to be, but I think it would be quite hard to get past the title, because people get caught up with those women and things, don't they? When I was doing some background reading for this, I just realised how much of an issue that had been. So I think the title would need to be changed. I'm not saying the title wasn't appropriate at all, but I think some debate has become a little bit too inward-looking about what we call things and where that positions us in the academy. Does that make sense?
Absolutely.
Yeah. I think it would be very hard to write a book as sort of straightforward and clear and motivated as this one is now. There would be far more caveats and maybe.
That's interesting. I think that depends on the authors.
Yeah.
I think a book like this could be written again, and it would just be kind of an updated version, not of the same kinds of topics that are in this book, but along the same methodology, using the same methodology, using the same model, women's lives, like Stone Doll's book for 2018, this book for 2018. So in that sense, yes.
Insights or comments of each other's.
I'm just pondering on that last question, so I'll come up with a good answer in a few hours as well, and Brenda will be thinking about it some way. But I think one thing that would change if you wrote a book like this again is that you would have much richer footnotes, because there is so much more work to support the arguments that you were making, I think, to really inform it. So whilst I think at the time you said you weren't sociologists and you weren't historians, I mean, Brenda's work in the Law Commission is just a really exemplary, a really fabulous example of how you use social science research to support arguments that you want to make in law. And I think that's what might make it different as well. You'd have more scholarly footnotes, I imagine, because there's so much more that's gone on in the back of this.
One of the things I was thinking about during your your words, Linda, was the whole idea of being a pioneer. Imagine trying to do what we do now when there is no place to publish what you write, when there are no networks and conferences and streams at conferences to do this in. That hadn't occurred to me. I knew that was the case, but that hadn't occurred to me how difficult it must have been to draw upon everything that you two drew upon, to do the work that you did, but to do it almost in isolation, like Daniel Boone going through the forest without having, networks to draw upon. And obviously you did. There were other women who were doing some of that work, but not in an institutionalized kind of way that exists now.
I mean, I think you mentioned somewhere in the book that there was a group of law teachers, women law teachers.
Alan's here, Allison's here. There was we weren't totally in isolation. There was the women law teachers, which gradually expanded. And people were doing very vibrant work. And there was some links with the Americans who were working here. I think, Brenda, you...
Yeah, Mulcahy.
Anna Mulcahy, who I then went to visit in Berkeley.
She came over to spend a few months in Manchester as a Simon professor. And she, of course, had done a massive casebook on women and the law with Ruth Bader Ginsburg. So that was quite an inspiration as well. And she was so clear about some of the issues where I had allowed my male colleagues to influence what I thought the right answer was, especially to things like rape. That was enormously helpful and inspiring and reassuring.
And I have to say, Linda talked about the law and discrimination course. Actually, I just used the students as research assistants because what they had to do was a dissertation. And basically, people came out, I can't remember what yours...
You were on maternity leave the year I did it.
Oh, right,
there you go, that's it in your place.
But people did the law of midwives, as well as abortion and other... people were absolutely amazing, and not all about women, because we covered all sorts of discrimination. So looking at ethnic minority women, nobody was doing those things. And the other thing is that we had in Southampton a law clinic. I think you had a law clinic in Manchester as well. So and I was teaching on a second chance for women course. And I remember at the time the Law Commission had a green paper on the legitimacy, and I got the students on the second chance for women to write in, having translated for them what the Law Commission green paper said, which was an education for me, it was just inaccessible. And so we were learning from people's actual lives, and that was really important, wasn't it, Brenda? Very grounded. So it was a wonderful sisterhood, but it wasn't an academic sisterhood. And I remember when we met last, Anna and I reminiscing that people just, our senior academic, male academic colleagues, just thought we might as well be writing shopping lists. Was that the word? Yes.
But there must have been less choice of journals where you could place your work. I mean, I think were you instrumental in setting up the Journal of Social Welfare Law?
Yes,
I mean, that gives it out.
Yes, I was the first legal editor of that. So, and that started in 77 or 8, something like that. Yes, Sue's entirely right. She wrote a brilliant article for us, and that's one of the reasons why it occurred to me to suggest that she might be the partner in the book. So, yes, we definitely did have things that were of particular interest to women in that journal. And there was a lot of interest in, the Legal Action Group, of course, started up in the 70s. So it wasn't a time when people were more interested in what we might call poor or disadvantaged folks' law than people had been when I was an undergraduate in the 60s, when we were taught our family law pre-1963, 9 family law, and our teacher told us to go away and forget it when we became wives and mothers, because knowing our rights would make us less good wives and mothers. And that was before the law had actually become halfway acceptable. So there was a big change. That's in attitudes, and we were just. It was probably a good thing that the book was delayed a bit, because I think we caught at the beginning of a wave, which really it would have been too much ahead of its time if it had been in the mid-70s when it was first being talked about.
I couldn't have written it.
No.
Without the work.
So, moving up to questions and comments from you, the audience. If you could just briefly state who you are when you're making your comment or asking your question. I actually had another sort of question, comment, which was about activism, and so many of the changes in the areas covered by the book, equality, sexuality, violence, welfare state, were achieved through a combination of political activism, legal reform, law reform, social change, external pressure, membership of the European Union, for example, with regards to equality law. And I suppose there's a couple of questions, which is, to what extent do people think that there is that dialogue in terms of feminist activism and feminist scholarship from this theory that one sees feeding into the book? And also, to what extent is legal scholarship able to push legal institutions to even recognise some of these persisting inequalities, because they just were not visible. You could see in the chapter of the book, some of these questions were not visible as problems to the law.
I think one of the things the book does really well is what we would now call legal pluralism, although it wasn't called that in 1984, I wouldn't have thought, in the sense that the changes that you were talking about earlier, Sue, that were important were happening not only at the level of formal law made through Parliament or made by the courts. And so the activism would have been important in that aspect if we think about how women's lives are so much more, not more, but are so intricately involved with committees and groups and schools and things that aren't formal law, top-down law. It's the kind of activism and the kind of getting people involved in those areas as well. And I think that's legal pluralism, isn't it? That seeing law as coming from all sorts of different places. So yeah, I think the activism is important.
It makes me think of sort of I think one of the other things, and I like to talk, I'm going to keep saying I'm coming late to it because I really feel at times like this that I am, but the sense in which what is, I suspect, maybe slightly different today is the sort of the engagement between feminist legal scholars and feminist academics within the academy and activists outside the academy, and the way in which, because of the fact that there's more places for us to publish our work, because there are now more of us are professors, because there's greater numbers of feminists within the academy and so on, this enables us to sort of adopt in strategic and instrumental terms the authority of the academy to support the activists. So it's not so much that we are activists, although I'm sure that people would describe themselves in that way, but I'm sort of thinking about occasions where we're able to be sort of wheeled in as the professors to make a particular point in relation to a particular issue and use that kind of mantle of authority, but then speak about feminism and speak about women's lives and speak about it. And so that's part of the change, or perhaps part of my reflection of where we are now, is that sort of we're able, that I'm grateful for the movement and the support to allow me to basically be able to sort of, I don't know, use my feminism through the voice of authority, I guess. Can't think of a way to put that, but I'm not sort of, I think it's sort of, I like being able to think that as a public servant, I'm a professor, and then I can sort of, you know, put myself out there and say, look, if you just need someone to say this is what should happen, and other people think that it's a good thing if you're working in an institution, and I can use that to help you lobby to change a particular law, to make a particular case, that's just great. And so it's sort of the progression has allowed people to do that perhaps in a different way to the way that was happening in the sort of 70s and 80s, where it was much more the hierarchy hadn't was still composed.
I mean, I almost can't conceive of feminism without activism, really. And I suspect we've all been activists in one way or the other. I just can't conceive that. And I think one of the fabulous things about feminism is that we can keep theory in its place as well. I'm not saying that theory is incredibly important for us to see some of those structural inequalities and cultural components of sexism that we all worry about, but it's just the activism. I mean, I will see the theory through the activism. You know, you can be working with somebody who isn't terribly well educated or terribly well resourced, and they just say something and you think that's quite a profound philosophical point. So I think that's something that feminism has always been really good at, is seeing this symbiotic relationship between the academic enterprise and theory and activism. And before I came to the Law Commission, I was working at the Bethnal Green Rights Shop, and it taught me so much. I did 6 months there, and I spent most of my time doing pregnancy tests, because we gave free pregnancy tests, and you really quickly realise what is affecting people. And we took a lot of claims that the local law centre would take on behalf of the claimants' union. There was the one-off discretionary payment that you would get for a single item that you were in need for. And we used to take mattresses to the tribunal because people had asked to have a new mattress in the rented accommodation they had, and these mattresses were horrible. They stank, people had slept on them, they had sex on them a lot. And they would ask for a new mattress and it had been turned down, so we used to take the mattress to the tribunal. I do remember quite a few interesting days when the van didn't turn up on time. We thought we'd like to take the mattress on the bus, but God teaches you a lot about law, it really does. And we knew we were going to lose those cases, actually. It was about still protesting. You know.
Well, that's the thing. Feminism is born of activism. There would be no feminism if it hadn't been for the women in the 19th century and the 18th century. And it doesn't mean that feminist theory is any less sophisticated than any other theory. It just means that the theory was developed from this way rather than from this way.
I see this has generated a few questions. So, okay, I think it's time to draw to a close. So I want to say thank you so much to Susan and Brenda, Fiona, Linda, Alison and Erika, and thanks, and also thank the team behind the Open Access Book Project, the IALS Digital, and in particular Stephen Whittle, who during the course of the progress of his book was the IALS Digital Manager, very much part of the team that made the republication possible. So thank you, and you're all very welcome to stay for reception afterwards.